Dear colleagues, dear students, ladies and gentlemen, I'm pleased to welcome you to the 8th International Conference of the Series Greek and Foreign Civil Procedural Systems. Looking back, I realized that it is the first time that the joint conference Greek-Polish, Polish-Greek has been held up to now, and I'd like to express my wish that this is only the beginning, that many other similar joint events will follow. Digitalization and AI open a new path in civil procedure, a path that balances between efficiency in justice and risks for the fundamental principles of civil procedure. It's a difficult balance, and our colleagues who are all very distinguished academics are going to highlight the most important points of the topic. So today I enjoy the privilege of welcoming our colleagues from Poland and thank them for accepting so gladly our invitation. Professor Anna Kosciolek, University of Rzeszow, Professor Flaga-Gieruszyńska, University of Szczecin, Professor Andrzej Olaś, Jagiellonian University in Krakow, who honor us today with their presence. Thank you very much. I'd also like to thank our Greek colleagues, Professor Michalis Markoulakis, Law Faculty of Athens, Professor Dimitris Michiotis, Law Faculty of Thrace, Dr. Eugenia Ferentinou, Open University of Cyprus, and of course, special thanks to the Judge of Appeal, Ioanna Mamali, who had the responsibility of presenting the concluding remarks of the conference. So, since it's time to start, I'd like to mention that according to the program that you have possibly already seen, there are 3 subtopics on this conference: e-civil trial, e-auction, and AI. And there is also a slight change to the program. We will start with e-civil trial, we will continue with AI, and in the end, we are going to have the e-auction, and of course, right away after that, the concluding remarks of the Judge of Appeal, Ioanna Mamali. I will preside over the first session. My colleague, Professor Diamantopoulos, will preside over the second session. And as you have seen already in the program, there are 2 speakers from Poland and from Greece for each topic. In the end, we will have the concluding remarks by the Judge of Appeal, Ioanna Mamali. So I'd like to thank Circular's publication for their support, excellent as always. Thank all of you for attending the conference. And now I will give the floor right away to our first speaker, Professor Anna Kosciolek, who is a professor in the University of Rzeszów, and she is also a head of Department of Civil Procedure in the same faculty. So Anna, the floor is for you.
Thank you very much. Let me just upload the presentation. I think I will just do what I did at first when I tried to, okay. I think I am having some technical difficulties. Can you please tell me if you see the presentation?
We see, but not presentation, only file. So you have to put the show.
It's now okay? Or is it?
Now it's perfect. Now it's perfect.
Okay. So I will just stay with this view. I'm not seeing anything but my presentation, so I hope this works. First of all, before going into my topic, I would like to express, I would like to thank the organizers, especially Professors Makridou and Diamantopoulos for the invitation, for the possibility to meet and compare our legal systems in terms of digitalization. Without further ado, as our time today is limited, I will now move to discussing my topic for today's conference, which is to present digitalization in terms of the civil trial in Poland. So basically, I will address digitalization of civil litigious proceedings in Poland. And to start with, let me briefly outline the background. Okay, so in Poland, the foundations of digitalization of civil proceedings have been developing for over 25 years, so it's quite a long time, to be honest. Of course, I will not discuss the entire legislative history, but I will just mention, because it is worth noting, that for quite a long time, digitalization in Poland covered only some certain areas in which the legislator explicitly allowed the use of ICT tools. This model of digitalization is very often referred to as so-called insular digitalization, because for a long time we only had some separate digitalized islands in procedural terms. A real turning point came during the COVID-19 pandemic, because this was the time when the pace of change increased significantly. This was obviously mainly driven by the need to ensure the functioning of the courts in this particular demanding time. But importantly, many of the solutions introduced at that time were not only temporary measures, but actually they were later incorporated into civil proceedings on a permanent basis. So what was first emergency solutions became then lasting elements of civil proceedings. So currently, the most important ICT applications in the civil litigious proceedings in Poland include electronic writ of payment proceedings, electronic service of court documents and pleadings, electronic submission of pleadings, remote court sessions, and remote taking of evidence. And I will now briefly discuss each of these institutions. Let me now turn to what can be considered a genuine breakthrough when it comes to digitalization of the Polish civil proceedings. And by a breakthrough, I mean the introduction of the electronic writ of payment proceedings. The electronic writ of payment proceedings were introduced in 2010 as one of the so-called separate proceedings. They were based on the traditional model of payment order proceedings, but they were also inspired by foreign solutions, such as the UK system of money claim online and German automatisiertes Mahnverfahren. The main goal was to make proceedings faster, cheaper, especially in simple and uncontested cases, by means of combining traditional proceedings with ICT tools. And as a result, the EPU, which stands for Electronic Writ of Payment Proceedings, became the most digitalized form of civil proceedings, litigious proceedings in Poland. The personal scope of the EPU is quite broad. It was originally designed mainly for mass-scale plaintiffs, especially entrepreneurs pursuing claims which are based on invoices or bills. However, from the legislative point of view, any entity with the capacity to be a party to civil proceedings can use the EPU. The main limitation is that a payment order cannot be issued if it would need to be served on the defendant outside of Poland. When it comes to the subject matter scope of the EPU, these proceedings apply only to monetary claims, regardless of their value. However, in practice, the system, the EPU system, does not allow claims that exceed 100 million Polish zlotys, and it is said to be only because of technical, not legal reasons. Additionally, only claims that became due within the last 3 years may be pursued in these proceedings. The proceedings is highly centralized. They are handled by one specialized court. We call it the electronic court, the e-court. It is located in Lublin, and it has jurisdiction over the entire country. All the judicial actions in the EPU, they are carried out and they are recorded in the electronic court's ICT system. The case file is actually fully electronic, and it includes both court documents as well as party submissions. And even if a party, meaning a defendant, files a document in a paper form, the document is digitalized and then added to the electronic file. The principle of electronic communication applies mainly to the claimant. The claimant has the obligation to file all pleadings exclusively through the electronic court system. The statement of claim, it is issued, it is submitted only through an online form. And what is important, the claimant does not attach any evidence. The claimant only indicates evidence. This is because evidentiary proceedings is excluded in the EPU. This means basically that the court issues a payment order mainly on the basis of the claimant's statements. The court examines the case in camera, which happens without the participation of the defendant. If the payment order is issued, it is served, of course, it is served electronically on the claimant, who is obliged to communicate with the e-court only electronically. And it is served traditionally by post on the defendant, together with the statement of claim. And the defendant has then 2 weeks either to satisfy the claim or to file an objection. The objection does not require detailed justification. Basically, if it's correctly filed, mostly on time, the payment order is annulled and the proceedings are discontinued. However, the claimant may then refile the case before an ordinary court. And what is important, if it's done within a prescribed time limit, the claimant keeps the original filing date. If no objection is filed, the payment order becomes final and the court issues an enforceability clause, which happens automatically ex officio, and the claimant may then start enforcement proceedings, either electronically or in the traditional way. Let us now move to the next topic, which is electronic service of documents. Electronic service is broadly considered as a natural direction in development of civil proceedings. It is faster, it is cheaper, it is more efficient than traditional paper-based service. However, for many years in Poland, service of court documents and pleadings remained mainly paper-based. Electronic service was available only in limited proceedings. First of all, the EPU I have just mentioned, and secondly, in some non-litigious proceedings, mostly registration proceedings. This changed drastically during the COVID-19 pandemic because at that time, electronic service was introduced on a broader scale. It was introduced under special COVID-19 legislation, so it was introduced outside the Code of Civil Proceedings. It operated through the so-called information portal. An information portal, to put things simply, is an online platform which was originally created to give parties easier access to information about their cases without the necessity of contacting courts directly. During the pandemic, service through the information portal was introduced, and during the time it applied only to professional representatives. And at that time, it became the primary and default method of service, which meant that court documents were generally delivered through the portal, and no traditional postal service was used. It was used only when the presiding judge expressly ordered it, for example, when electronic service was not feasible. So there was no parallel service because electronic and postal service were treated as legally equivalent. Although this solution was temporary, it proved effective. And after the pandemic, by the end of the pandemic, it was incorporated into the Code of Civil Proceedings. At first, when it was incorporated to the code, it had a relatively narrow scope of application because it applied only to selected professional representatives, such as advocates, attorneys at law, patent attorneys, prosecutors, general counsel to the Republic of Poland, and a pension authority. It also covered only court documents, not pleadings submitted by the parties. And this quite narrow scope of application is now being significantly expanded, actually this year, because from the 1st of June this year, so roughly in a month, court enforcement officers and permanent court mediators will also be subject to this mandatory portal service. At the same time, which is very important, at the same time, any party to the proceedings will be able to opt into this form of communication, into this form of service. This is a very important step because electronic service is moving from a solution limited only to professionals to one that becomes generally accessible. The range of documents covered by portal service is also broader. Up until recently, it covered only court documents, not pleadings, just the way it was during the pandemic. However, under new procedural rules, also copies of pleadings and other documents which are submitted by the parties of civil proceedings are also serviced via the portal, provided that they are available to the court electronically. And this is very closely connected with the fact that filing pleadings via the portal was introduced at the same time. I will discuss this issue in a minute, actually. But first, I would like to address another important change, which came into force on the 1st of March 2026. This change concerns so-called direct service between professional representatives. And from the 1st of March 2026, the information portal can also be used for such service. Direct service is applied in cases where both parties are represented by professional representatives, and they are often required to serve pleadings to each other instead of through the court. And if a pleading is filed through the portal, a copy is almost automatically sent to the opposing representative. So in this way, filing pleadings through the portal also fulfills the obligation of direct service. And if a pleading is submitted traditionally outside the portal, the service via the portal is not obligatory. It remains optional. The next topic I would like to address, and I have already mentioned it before, it includes electronic submission of pleadings. When it comes to this issue, for a long time, the EPU I have mentioned in the beginning were the only area of litigious proceedings where electronic submission was possible. There were also some limited forms of electronic submissions in non-litigious proceedings, mostly in registration proceedings and land and mortgage cases. But beyond that, paper filing, paper submission was a rule for a very long time. And even during the COVID-19 pandemic, the legislator did not introduce any obligation, even to professional representatives, to file pleadings electronically. This changed this year, actually, quite recently, because on the 1st of March 2026, and the most important change that happened on that day was the introduction of mandatory filing of pleadings through the information portal, which was up until then used only for service. At this stage, however, the obligation is limited in terms of entities and in terms of pleadings which are covered by this type of service. Moreover, it is also subject to a transitional period. This is obviously understandable because what's happening in Poland right now is that electronic filing of pleadings is being introduced on an unprecedented scale. So what we had only as small digitalized islands is actually being transformed into the entire civil proceedings. The obligation currently applies only to selected professional representatives, such as, for example, advocates or attorneys at law. So in other words, it concerns entities that have professional capacity on one hand and technical resources on the other hand, so they can actually use digital tools effectively. Moreover, I mentioned the transitional period because the strict application to file pleadings electronically will apply after a 1-year transitional period. We are actually in this period right now, and filing through the portal remains optional until next year. The obligation to file pleadings electronically covers only specific types of pleadings. They were selected based mostly on their nature, on the typical number and size of attachments, and based on how frequently they are filed in practice. So to simplify things, there are two main groups of pleadings covered by the electronic submission. The first group includes we can say simple pleadings containing short statements, notifications, or procedural motions. And the second group includes all pleadings submitted in appeal proceedings, including those pleadings that actually initiate such proceedings. As a rule, pleadings are filed together with attachments. However, there are two important exceptions. The first one is connected with a situation where we have a document which originally exists in a paper form, and it must be submitted in this paper form because there is a legal requirement to do so, or the court decided that it should be done this way. And such attachments have to be delivered to the court outside of the portal. So traditionally, within 3 business days from the electronic submission of a pleading itself. The same applies to attachments that cannot be submitted electronically. For example, when we have very large files that exceed system limits, or when we have physical evidence that cannot be digitized. In such cases, attachments are submitted separately in a traditional form, but the pleading itself is still filed via the information portal. The obligation to use the information portal is not absolute, obviously, because of technical problems that can actually prevent effective filing. And that is why the Polish legislator decided that if a pleading cannot be submitted on the last day of a deadline, because the information portal is unavailable due to technical reasons, and these are technical reasons attributable to the court. So, for example, we have a system failure. The pleading should be filed on the next working day via the portal. This change that I am discussing is also accompanied by sanctions for non-compliance. The pleadings which should be submitted through the portal is submitted outside the portal, so in a traditional manner, it is treated as it had never been filed. the party is notified of this. And the same applies to the opposite situation, that is a situation when a pleading is incorrectly filed through the portal, despite the lack of legal grounds to do so. Let us now move to the next topic. The next topic includes remote court sessions. Remote court sessions were introduced in 2016. However, it was many years ago, almost 10 years ago. However, the original model was very impractical at first, because participants could actually join the court session remotely only from another court building. And for this reason, actually not a single remote court session was conducted before the pandemic, although we have the legal framework that actually allowed us to do so. This obviously changed during the COVID-19 pandemic, when special legislation was adopted and parties were allowed to participate in court sessions from any location, not only from court buildings. And this solution proved effective and was later incorporated into the Code of Civil Procedure. Under the current legislation, a remote court session is a public court session, which is conducted with the use of technical means that allow participation at a distance. So this is a very broad definition. It covers not only hearings, but also generally all public sessions. However, sessions that are held behind closed doors are usually excluded, so they cannot be held remotely unless all participants are present in court buildings only. A remote session requires technical tools which actually enable someone to participate in a court session without being physically present in the courtroom. In practice, this means that we need an internet access, of course, and we need a video conferencing system with both video and audio, because participation by audio only is not enough. The decision to hold a remote session belongs entirely to the presiding judge. The judge must assess, when deciding how to hold a court session, the judge must assess whether the nature of actions that are to be undertaken allow for it, and whether the remote participation will not affect parties' rights, as well as the proper course of proceedings. A remote session can be ordered either on the judge's own initiative or on the request of a participant, such as a party, a witness, or an expert. The decision is issued in camera. It cannot be appealed, mostly because participants still have the possibility to appear in person, even if the session is remote. So they cannot appeal against such decision. In practice, the judge, the court clerk, the court itself, let's say, they remain in the courtroom. This is mandatory for them. Other participants may join from, we can say, almost any other location, provided that they inform the court where they actually are, and the condition in such a place are appropriate. In some situations, the judge may require participation from another court building. Moreover, if we have persons which are deprived of liberty, puberty, or they undergo therapy, they have to participate from places such as, for example, prisons, detention centers, or medical facilities. And now we come to the last but not least topic for today, which is remote taking of evidence. The possibility of taking evidence remotely was introduced into the Code of Civil Procedure almost 20 years ago. Today, it allows the court to decide that evidence may be taken remotely during a remote court session, provided that the nature of the evidence actually allows to take it remotely. This applies mostly to personal evidence, like examination of parties, witness testimony, or expert opinions. As a rule, the court decides on taking evidence remotely, usually on the basis of a party's evidentiary motion. If a party did not initially request it, the party still may submit such a request. Similar requests can also be made by other participants, such as witnesses or experts. And although the court generally decides if an evidence is taken remotely, in some cases, the final decision actually depends on the parties. Most importantly, a party can object to remote examination of a witness as long as the objection is submitted within a prescribed time limit. If the objection is actually submitted correctly within the time limit, the court must summon the witness to appear in person. The party does not even have to justify this objection. So meeting a deadline is just enough for the court to be obliged to summon the witness to appear in person in the courtroom. A similar mechanism applies to the examination of parties, but not to experts. In the case of experts, the court has we can say greater discretion. It can require justification before deciding on in-person examination. And for this reason, many argue that a similar requirement should be also applied to objections against remote examination of witnesses. All of the digital solution I have discussed in relation to civil proceedings, civil litigious proceedings in Poland, apart from the EPU, they also apply in principle to non-litigious proceedings. At the same time, some elements of digitalization are specific to non-litigious proceedings only, especially it happens in registration proceedings, in land and mortgage cases. I briefly discussed these issues in my post-conference article, but unfortunately, due to time limits, as time flies, I cannot address them in detail today. So because of the time limit, let me just conclude with a short summary. Until recently, digitalization of litigious proceedings in Poland was very limited, was fragmented. It mainly covered selected digital islands, as I said in the beginning. The COVID-19 pandemic exposed the weaknesses of this paper-based communication system, and it accelerated changes. And as a result, Polish civil proceedings has moved from isolated, from partial use of ICT tools through pandemic-driven emergency solutions towards a more systematic digital transformation. At the same time, which is completely obvious and natural, this process is still ongoing. So further development is to be expected, is necessary. So we are actually expecting other legal changes, other amendments in this area. Thank you very much for attention.
Thank you very much, Professor Kosciolek. Thanks to your presentation, I think we all now have a very clear picture of the steps that the Polish legal system made towards digitalization, not only nowadays, but also the evolution. And it's very, very obvious that the progress is very, very big. And I have to admit that I was really impressed by the electronic rate of payment that you have, and by the fact that this institution was introduced in 2010, if I'm right. This is very, very early, before everything in digitalization starting to evolve and to grow up. So thank you very much. And now I give the floor to our colleague, Professor Michalis Markoulakis of the Law Faculty of Athens, to present the e-civil trial from the Greek perspective. So, Professor Markoulakis, the floor is yours.
Thank you, Professor Makridou. Before I begin with my presentation, I would like to thank you and Professor Diamantopoulos for organizing this event on such a timely, very important and significant topic, and of course for entrusting me with this presentation. And many, many thanks, as always, to Sakoulas Publications for the organization. And I waste no time because time flies, as our colleague said, so I try to share my presentation with you. So as Anna said now, if everything is okay, I can see nothing else but my presentation, and I proceed. Dear guests, ladies and gentlemen, in Greece, as internationally, the digitalization of justice has long been a key topic of discussion. It is widely recognized that the use of means of modern technology can contribute to modernizing and accelerating the justice system. At the same time, caution is advised so that the introduction of e-trial methods does not compromise the fundamental procedural guarantees and principles or endanger the personal data of the parties, of all persons involved. The idea of performing procedural acts by means of modern technology was introduced in the Greek Code of Civil Procedure for the first time in 2011. Since then, the relevant framework has been gradually further specified, and the use of electronic means has been expanded in a step-by-step manner. In the 25 minutes that I have at my disposal, I will attempt to briefly outline the legislative evolution and the current framework of Greek e-trial in its main fields, and that is e-filing and e-service of judicial documents, a digital case file management, communication between the court and the parties, and last but not least, examination of witnesses and conducting the hearing by means of video conference. The first field in which electronic means are used in civil trial under Greek law is the filing of judicial documents, and by that I mean documents entail all kinds of procedural acts of the parties. After the 2011 reform, the Code of Civil Procedure in its Article 119 provides that judicial documents may be filed also by electronic means. That means beside the traditional hard copy method. The details of the electronic filing procedure are specified by a Presidential Decree 25, the year 2012, and especially regarding the parties' pleadings, and by that I mean the judicial document that contains the factual allegations of the parties, as well as the supporting evidentiary documents. Details are specified by another Presidential Decree, number 150 of the year 2013. A significant milestone in the evolution of electronic filing was the development of the so-called integrated system of civil and criminal justice case management. The first phase of the project began in July 2014 and was completed in January 2019. It covers the courts of Athens, Thessaloniki, Piraeus, the biggest cities, and of Chalkida, in total 41 courts, as well as Greece's Supreme Court, the Arios Pagos. Since 2020, the second phase of the project is in progress, which aims at extending the integrated system to all courts throughout the country, all over the country. The integrated system is based on interoperability with information systems of other bodies and, most importantly, with a system of the plenary of bar associations. Initially, Article 119 of the Code of Civil Procedure allowed the electronic filing of judicial documents provided that they bear an advanced electronic signature. In 2021, the provision was modified in order to be adjusted to the legal framework of the EIDAS regulation. In its current form, now Article 119 provides that the document to be filed must bear a qualified electronic signature, and the same applies to the court's electronic report confirming the filing as well. The same reform also contemplated an exception from the said requirement from the requirement of a qualified electronic signature, where a secure, authenticated, closed system in the sense of the EIDAS regulation exists within the court, allowing identity verification. The integrated system for civil and criminal courts is such a closed system, since only lawyers that are authenticated using their credentials can enter into the system and use it. However, in practice, the system still technically does not allow a document that does not bear a qualified electronic signature to be uploaded and thus electronically filed. In broad terms, the procedure for the e-filing of judicial documents is the following. The lawyer logs into the system of the plenary of bar associations using their credentials. Then the lawyer fills in the details of the clients, of their client, or the type of the procedure, and the number of copies they wish to be issued, and proceeds with the electronic payment of the court fees. In the case of the e-filing of pleadings especially, the lawyer, it is very important, must also fill in the number of the filing number of the pending legal remedy in order that the system finds the legal remedy and link the pleadings to it. Then the lawyer is automatically redirected to the integrated system, where they proceed with the electronic filing of the judicial document by uploading the document on the relevant field. The document must be in PDF form and must bear a qualified signature, e-signature. Otherwise, the system does not allow it being uploaded. The e-filing procedure is completed when the court clerk sends the response accompanied by the copies that the lawyer asked for, and with the filing report, which also must bear a qualified electronic signature. It has been rightly suggested that this response, the response by the court, constitutes a requirement for the legal existence of the electronically filed legal remedy. In other words, the filing has not yet been completed if the filing lawyer does not receive the response. It is explicitly provided for that the filing time is deemed to be the date and time when the court clerk sends the response. Against this background, the question of time limits has given rise to a noteworthy divergence. Article 144, a general provision of the Code of Civil Procedure, provides that procedural time limits, procedural deadlines, expire at 7 p.m. on the final day of the time limit. However, Electronic filing is technically possible at any time. Furthermore, a special provision, the provision of Article 19, Paragraph 5 of a law of 2014, introduced a legal fiction deeming electronic filings performed at any time on a business day to have been filed within working hours. It is thus disputed if an appeal that is electronically filed after 7 p.m. on the last day is filed timely or not. The Areospagos has issued conflicting decisions on this issue, and legal scholars are similarly divided. I subscribe to the more compelling view that Article 19 is indeed, creates indeed a legal fiction that supplements, it is a special provision that supplements the general provision of Article 144 of the Code of Civil Procedure. And thus, a legal remedy that is electronically filed after 7 p.m. of the last business day of the time limit is deemed as having been filed within the working hours of the clerk's office, and it is thus has been filed timely and is admissible. Nevertheless, it is clear that legislative clarification is needed. It is here advisable. On the other hand, where the Code of Civil Procedure contains a special provision setting an earlier deadline, that is a time that falls short of the clerk's office closing time, then this special provision of the Code of Civil Procedure prevails. For example, pleadings, according to Article 237 of the Code of Civil Procedure, have to be filed until 12 o'clock noon of the last day of the time limit. In my view, this provision applies irrespective if the pleadings are filed electronically or in hard copy, either way. The same procedure is followed for the submission of evidentiary documents that the parties produce to the court in order to prove their allegation. The system, the integrated system, provides specific fields where the documents may be uploaded in PDF form. Here, it is not obligatory that this document bear a qualified electronic signature, and this is because under Greek law, the court may take into account means of evidence that do not meet the legal requirements, and this includes, according to the prevailing opinion, uncertified documents. Documents that are submitted in electronic form and do not bear a qualified electronic signature are considered by the court and evaluated freely as means of evidence that do not meet the legal requirements. On the other hand, of course, electronic documents that bear a qualified electronic signature, either of their issuer or of the lawyer who certifies them, they produce the probative force, the probative value of evidentiary documents, and that means, in principle, full proof. Finally, the Code of Civil Procedure contains a special provision for small claims, with claims with a value up to 8,000 euros. Article 468, paragraph 4 of the Code of Civil Procedure provides the use of standardized documents and means of technology. However, this provision has not yet been implemented, as the relevant ministerial decision for its implementation has not yet been issued. The 2011 reform also introduced the possibility of an electronic service of judicial documents as a non-mandatory, optional, alternative method to physical service. In Greek law, the court bailiff is the competent authority for the service of documents, and this role is maintained for electronic service as well. As a condition for the electronic service, the document must bear a qualified electronic signature. The service of the documents by electronic means is deemed to be completed only if an electronic acknowledgement of receipt is returned to the court bailiff by the recipient, by the addressee, which must also bear a qualified electronic signature. The court bailiff is obliged to include this electronic receipt sent by the addressee in the report of service that the court bailiff draws. Otherwise, it is explicitly provided for that the service is null. In addition, The court bailiff must receive this electronic receipt, this electronic acknowledgement, within a specific time limit, within 24 hours from transmission of the document. Otherwise, it is also explicitly provided for, the service is deemed legally non-existent, and it is then mandatory to perform the service via physical means. Furthermore, electronic service is possible only if the addressee has declared a unique email address in the National Communication Registry. This requirement ensures, and I quote here from the explanatory memorandum of the relevant law of 2020, that the optional procedure of electronic service is limited only to those who consent to it. These requirements, on the one hand, of course, secure the right of the addressee to be heard. On the other hand, though, they diminish the practical importance and the practical implementation of each service, since they make it fully dependent on the will of the addressee. The technical details for the procedure of the electronic service are set out in a ministerial decision of the year 2022, which provides that electronic service is performed through the electronic service system of the Federation of Court Bailiffs. A court bailiff enters and logs into the system using their credentials. They find and select the addressee via their VAT number. Then the court bailiff uploads both the report and the document to be served in PDF document. The latter, the document to be served, as already mentioned, must bear a qualified electronic signature. And then the system sends an email notification to the addressee to their email address, which contains a link. Through the link, the addressee enters the electronic system and is authenticated using their credentials of the General Secretariat for Information System of the Ministry of Digital Governance, or alternatively, using e-banking credentials. Then the addressee is asked to sign the report by applying a qualified electronic signature. Upon completion of the service, the electronic service system notifies the bailiff via email that the service has been completed. Concerning again here the time frame for the service of document, the Code of Civil Procedure in its Article 125 provides that the service of documents may not be effected at night, that is between 7 p.m. and 7 a.m., as well as on non-business days, including, according to the Civil Procedure Code, Saturday. It is thus disputable if this general provision is applicable also to electronic service. In my view, it is applicable. The non-application of Article 125 is difficult to justify, since, unlike the case of electronic file, here there is no special provision that repeals or substitutes the general provisions of the Code of Civil Procedure, which set the time frame within which the service of documents is possible. Of course, again here the legislator must intervene to clarify matters in order to bring legal certainty. As a general observation, the legal framework regarding e-service is, in my opinion, characterized by legislative flaws, and probably for this reason, it has not yet been implemented in practice, with the notable exception of cadastre, where since 2024, the e-service of documents is mandatory. The electronic service is the only way that a court bailiff can serve a document on the cadastre. A further field of digitalization concerns case file management. For courts integrated into the integrated system, the court docket is maintained electronically, and the system supports case progress tracking. Furthermore, in 2027, a new paragraph was added to Article 119, the sedes materia, let me say, for e-trial in Greece, which for the first time provides the creation of an electronic case file within the electronic system, which contains all basic procedural and other documents, as you can see here on this slide, the initiating documents, proofs of service, pleadings, powers of attorney, etc. The legislative objective is to modernize and accelerate civil proceedings through the digital consolidation of critical documents in a unified, accessible, and functional environment. Digitalization also extends to communication between the courts and the parties or their lawyers. A ministerial decision issued in 2025 established an online notification service which notifies per SMS lawyers regarding the progress of their cases, most notably including the scheduling of their hearing dates and the issuance of decisions. In addition, several provisions of the Code of Civil Procedure provide for targeted communication between the court and the lawyers by email, aiming to accelerate the procedural management. For example, Article 227 of the Code of Civil Procedure allows the judge to call upon a party or their lawyer to remedy formal omissions, and this can happen, this notification can be sent explicitly by email. Furthermore, examination of witnesses or parties or conducting the hearing by video conference is a possibility under Greek law. It was at first introduced with the 2011 reform and has since been relocated. The provisions have been relocated within the code's systematic structure. Presidential Decree 142 of the year 2013 regulates in detail the prerequisites and the procedure for remote hearings and remote examination. The examination of witnesses is transmitted in the courtroom of the court, which is equipped with all necessary equipment, enabling real-time transmission of both and reception, of course, of image and sound without distorting the natural features of persons or the appearance of objects. And the Code of Civil Procedure explicitly provides that the remote examination is deemed to be conducted before the court and carries the same probative force, the same probative value as examination in open court. Legal scholarship generally accepts compatibility with the fundamental right to a public hearing with the principle of publicity, insofar as the examination, as mentioned, is transmitted in the courtroom, which is, of course, open to everybody. Concerning the principle of immediacy, it has been suggested that it is restricted when a witness or a party is examined not in open court but by video conference. However, the decision to conduct the examination by video conference is at the discretion of the court, which, exercising its discretion, must weigh the impact on the reliability of the examination of the witness, how this examination could undermine their reliability. Lastly, it must be highlighted that in February 2026, a few months ago, a new paragraph was added to Article 119, which empowers the court at any stage of the procedure from until the judgment becomes unappealable, to allow any procedural act of the court, of the parties, of their lawyers, or third parties to be performed remotely through the use of modern technology. It's a very broad provision. However, the details of implementation shall be specified by a ministerial decision, so we are going to see how it will be implemented and applied. In conclusion, Greek civil procedural law utilizes the means of modern technology in every stage, in all stages of the procedure, from its initiation until the issuance of the judgment. And most characteristically, the newly introduced Article 119, paragraph 6 extends very broadly the possibility of using electronic means to every procedural act. Regarding the e-filing and e-service, Greek law provides detailed regulation, and the development of the integrated system of civil and criminal justice case management has secured the necessary technical means. However, as demonstrated in the problem of the deadline for filing of appeals, interpretative issues arise, and they must be addressed in order to ensure legal certainty. So far, no real concerns have been expressed regarding the compatibility with the fundamental procedural guarantees and principles. It is very obvious, though, that the Greek legislator has opted for solutions that cause the least concern. The example of electronic service and its dependence on the will of the addressee is very characteristic. In this regard, it is a political choice of the Greek legislature that the performance of procedural acts by electronic means is still optional, which secures that everybody, even those who are not able to use modern technological means, have access to the justice system. It remains to be seen whether in the future and to what extent this will change, and for instance, e-filing or e-service becomes mandatory, like in the case of the cadastre. In my view, a serious problem which is a general problem of the Greek justice system, is that there are no officially available statistics as to the extent to which the use of the means of modern technology has been adopted in practice. And this, of course, makes it impossible to measure whether the digitalization of justice has succeeded or not, what its outlook is, and what further steps the legislator still has to take. Thank you for your attention.
Thank you, Professor Markoulakis, for your presentation. It is clear that if the use of electronic means remains optional, as it is in most provisions in the Greek Code of Civil Procedure, this makes lawyers and clients safer at the moment. But you highlighted this interesting problem and many others that arise on time limit, and this also creates problems of safety. Thank you very much for your presentation. And now we continue with the second couple of presentations on artificial intelligence. And we will start with the Polish presentation with Professor Andrzej Olaś, who is a professor at the Law Faculty of Law and Administration of the Jagiellonian University in Krakow. And he is also a member of the Polish Ministry of Justice Committees for AI. So we have an expert with us today, and I give the floor to Professor Olaś.
Good evening. Hello, everyone. First of all, before I move on to the substance of my presentation, I would really like to express my sincere gratitude to Professor Makridou and Professor Diamantopoulos and all the organizers for your kind invitation. It's a genuine pleasure and honor to speak at this conference, organized in the very cradle of European civilization and also law. Because when invoking all of these Latin maxims connected with used lex, it's very easy to forget that actually long before Roman law gave us those distinctions, actually the ancient Greece had already laid the fertile ground with its dike and nomos for all legal concepts and ideas that underlie the European legal tradition and still continue to shape the law across the Western Hemisphere and even beyond up to this date. So it's a real honor and pleasure for this reason. And now I will try to upload my presentation and move on to its contents. It should be already there. And now I will try to put it on the screen so that you can see it in its entirety. Yeah, can you see it now? Great, thank you very much. So now let me begin my presentation with a kind of a thought experiment. Imagine that you are involved in a civil dispute. A contract claim, just a property matter. You receive your determination, it's detailed, internally consistent, and legally coherent as well. Then you learn that it was produced without any human being having read your file. And would that trouble you? And if so, why exactly? That very question is at the heart of my paper, which examines the interface between artificial intelligence and the constitutional and procedural framework governing civil litigation in Poland. The questions it raises, however, are not just Polish questions. They are often of universal nature. They pertain to the very nature of justice itself. So the central observation underlying my research is the following. While data processing constitutes the body of civil proceedings, the civil proceedings cannot be reduced to it. Civil proceedings are first and foremost a social institution aimed at satisfying one of the most fundamental human needs, fair dispute resolution by an authoritative and impartial body. That human-centered perspective organizes the entirety of my analysis. For reasons of time, I will focus on 4 issues that are specific to the Polish jurisdiction, but also have broader relevance for Greek and European legal system or beyond. These are the regulatory framework, the constitutional limits on AI deployment, the interplay between AI and guiding procedural principles, and finally, the actual state of AI use in Polish courts. So what is exactly the normative framework, or rather a normative vacuum, so as to say? The simple and short answer to this question is there is definitely a significant vacuum in terms of regulation and legislation of this field in the Polish legal system. Because beyond the EU AI Act in force and partially applicable since August 2024, there is currently actually no Polish statute that would explicitly govern the use of AI in civil justice. Poland has not yet designated the national supervisory authority required by the EU AI Act. The draft law on AI systems adopted by the Council of Ministers on 31st of March 2026 is still some legislative steps away from becoming binding law. Most importantly, for today's purpose, neither the Code of Civil Procedure nor any other procedural statute addresses the admissibility, the scope or conditions of AI deployment in the administration of justice. In this vacuum, all questions, therefore, must be assessed directly through the lens of the Polish Constitution, the European Convention on Human Rights, and the guiding principles of civil procedure. Moving on to the taxonomy of AI applications in civil proceedings, the possibilities for deploying AI in civil justice span a broad spectrum, from purely technical and administrative support to full automation of decision-making process. At one end lies the full automation model. An AI system independently conducts proceedings and issues decisions without any meaningful human involvement. And this one is obviously the most constitutionally contested possible model. At the other end lies so-called semi-automation, where AI assists a human judge who retains final authority. Within this model, 2 variants or submodels carry fundamentally different constitutional weight. The first one is a so-called suggestion model, where AI proposes outcomes or provides input before the judge forms an independent view. This creates conditions for automation bias, unfortunately, the well-documented tendency to defer uncritically to algorithmic outputs. The second submodel is a confrontation model, in which AI intervenes only after the judge has formed a preliminary assessment, helping to review and refine this assessment or a draft of decision. because the judge's own thinking comes first, the epistemic autonomy is fully preserved. Though this submodel offers definitely much less potential for speeding up proceedings, which is one of the aim of deployment of AI in civil justice. So clearly there is a trade-off in terms of the risk and the potential benefits. For the purpose of my research, I distinguish 4 categories of AI application ascending in constitutional sensitivity. The first one is organizational and administrative tasks. These are solutions like anonymization of judgments, transcription of hearings records, case assignment, and scheduling. These solutions are lowest in terms of constitutional concerns, with the exception of case assignment, because the case assignment affects court composition and therefore also the right to a judge established by law. The second tier solutions is AI as judicial assistant, which includes legal research, document analysis, flagging of relevant case law, drafting simple procedural orders. Here the judge retains ultimate authority, but must genuinely exercise this authority. The principal risk here is, of course, the automation bias. The third tier solutions is AI in the role of court referendary. Here, for Greek colleagues, Greek audience, it requires a kind of clarification. So under Polish law, court referendaries are non-judicial officers, quite similar or analogous to the German Rechtspfleger. Yeah. So in Poland, they are empowered to issue payment orders, conduct registry proceedings, and also perform numerous other tasks, among others things, inheritance proceedings in non-contentious matters, as well as numerous enforcement actions in enforcement proceedings. All of them are, however, of course, subject to full judicial review. And in this vein, there is a constitutional question in whether that same logic also extends with appropriate safeguards to algorithmic systems, whether algorithmic systems can be implemented in milieu of court referendaries. The last tier, most problematic, is AI as decision maker. Here, AI system independently resolves disputes on the merits. So this one is, as I already suggested, the most contested, most restricted under current Polish constitutional law. Moving on to the constitutional issues that are at the heart of my paper. The starting point is that the Polish constitution does not mention AI at all. It's not a surprise because the constitution was drafted in 1997, when actually AI use was more perceived as a matter of legal futurism or even legal science fiction. So the constitution principles and other provisions must certainly be applied through interpretation, through adaptation. And in this respect, based on doctrinal discussions, I have identified 4 distinct constitutional objections, each grounded in a separate provisions and capable of standing independently. However, they are, of course, to some degree intertwined. The first one is the issue of the right to a court and fair trial, based on Article 45 of the Polish Constitution, which largely reflects Article 6 of the European Convention. Here, the dominant reading in Polish doctrine holds that the constitutional concept of a court presupposes a body of human judges. So an AI system is structurally incapable of satisfying the requirements of independence and impartiality in the constitutionally relevant sense. This is so because independence is a matter of conscience and professional integrity. It cannot be attributed to an algorithm. An AI system's impartiality, so-called impartiality, so as to say, is merely a function of the statistical properties of its training data, the inference method or model that is embedded in a given model used, and the values, conscious or unconscious, of its developers. The right of fair trial also implies the court's duty to give adequate reasons. Yes, and in this respect, even the most effective current AI models, particularly those based on machine learning and deep neural networks deploying sub-symbolic approach, they are precisely the most efficient but the least explainable. A decision produced by a black box algorithm cannot be adequately reasoned in the constitutionally required sense. Without a genuine explanation, the parties cannot effectively challenge the decision, and the right to appeal becomes nominal. The currently existing explainable AI methods still remain insufficient to resolve this problem. The second dimension of constitutional problems is the very system of judicial administration of justice and the principle of separation of powers embedded in Article 175, 173, and Article 10 of the Polish Constitution. These provisions establish what the Constitutional Tribunal calls the essential core of judicial power. That is a sphere of exclusive judicial competences that may not be transferred to any other organs of the state. Therefore, the final and binding resolution of legal disputes is the paradigmatic exercise of that power. The crucial distinction is between the administration of justice in the strict constitutional sense and the broader category of legal protection activities that I've mentioned before, because the court referendaries that I've mentioned exercise the latter, while the court and judges retain a monopoly on the former. Therefore, AI systems could perform legal protection activities subject to the full judicial review without major constitutional controversy. But they may not administer justice in the substantive constitutional sense, at least according to the majority views. There is still, however, another major structural problem specific to the Polish institutional architecture. In Poland, the Ministry of Justice, which is a central organ of the executive branch, vested with the broad supervision powers vis-à-vis the judiciary, controls the technical infrastructure of the courts, including IT systems. And this is indeed a very problematic in terms of a broader implementation of AI, because any meaningful AI system which would affect the substance of adjudication, even within a semi-automation model, if controlled by the executive, would constitute a constitutionally impermissible incursion into judicial independence under the provisions of the Polish constitution. Therefore, I submit that the design, the training, and the oversight of adjudicative AI must remain within the organizational sphere of the judiciary itself. The same, in my opinion, principally applies to nominally administrative tools such as case assignment algorithm, as long as they affect court composition and thereby the right to a judge established by law. Another dimension is the principles of democratic legitimacy and human dignity, which reinforce the constitutional picture as well. judicial power must remain in human hands. That is, in the hands of the peers, members of the community, answerable, morally responsible, and susceptible to democratic control. A binding decision produced entirely by a machine treats the person as an object of algorithmic analysis, as opposed to a human being. Therefore, the concept of justice, use as ars boni et equi, according to Latin maxim, it requires wisdom, it requires empathy and a sense of a fairness that even the most sophisticated AI does not and is in the foreseeable future cannot possess. Moving on to the procedural principles, going one step lower at this hierarchical ladder of norms, the starting point would be to state that despite many shortfalls, inconsistencies, and never-ending reforms, the Polish civil procedure is grounded in well-established principles. That is the principle of party equality and the right to be heard, the party disposition and the adversarial principle, judicial case management, publicity, immediacy, orality mixed with written elements, concentration of evidence, and the free assessment of evidence. Arguably, AI challenges all of these principles, but on the other hand, it may also enhance some or perhaps even most of them. Therefore, the integration of AI system will require careful adjustment in how these principles are understood, while also preserving the values that those principles protect. One point deserves particular emphasis, that is the party autonomy. Because where parties give their free and informed consent, AI-based dispute resolution mechanism operating outside the state court structure, based on opt-in model analogous to arbitration, with available challenge mechanism preserving recourse to a human court, they can be given legal effect. In other words, parties may accept simplified AI-assisted out-of-court dispute resolution, but the core guarantees of a fair trial remain non-waivable. Moving on to a final point of my presentation before wrapping up conclusions are the actual state of affairs and the current applications, developments that are pending. So let me now turn from the normative framework to the empirical picture, because here the gap between what the constitutional analysis demands and what is actually happening in Polish civil justice is one of the most revealing features of the current moment. The formal integration of AI into the Polish justice system is at the present time, the time I'm speaking to you, quite limited. It's essentially confined to two purely technical uses with no involvement in substantive decision-making. The first one is automated anonymization of judgments available, published on publicly accessible judgment portal of common courts, which runs since 2008. And the second application is a speech-to-text transcription system for hearings, which was launched in 2018 and still is under the development. So this level of actual implementation stands in stark contrast to most advanced jurisdictions leading in AI deployment and integration in their respective civil justice. However, what changed recently is the ministerial agreement, which was signed on 28th April 2025 between the Ministry of Justice and the Minister of Digital Affairs. This agreement includes three concrete projects that deserve your attentions. First one is Digital Judges Assistant, which is a 4-module system which comprises of document digitalization and robotic reading, a CJEU case law knowledge base, an automatic payment calculator for Swiss franc loan disputes, which are currently the most voluminous category of Polish civil litigation, and most significantly, another element of this program is an algorithm supporting the drafting of court rulings in those disputes relating to Swiss franc loans. The planned completion of this program is mid-2026, so it's supposed to be implemented quite soon. Whether it will be introduced on time, I'm afraid it's rather dubious. However, officially, this is what is announced by the public authority. The second element of that agreement is so-called electronic read of payment 3.0. That is improvements which are supposed to substantially improve the level of automation in the processing and validating digital documents within these proceedings, with also capacity for automated communication with external systems. This improvement in electronic read of payment proceedings are also expected in mid-2026, so also pretty much soon. And the third element is connected with the specialized court of competition and consumer protection, which is supposed to be transformed into a fully digital court, serving as a live operational test of the Digital Judges Assistant. The objective is to accelerate document analysis, identify connections in case law, and also automatically prepare draft judgments for judges to refine and then approve. Another element connected with the current state of affairs is a growing professional asymmetry, which becomes a structural problem. Because while courts have been adapting AI tools slowly, the legal profession has moved with remarkable speed. Actually, the two dominant legal information platforms, commercial platforms available on the Polish market, that is Lex by Wolters Kluwer Polska and Legalis by Beck, have both launched this year generative AI products embedded in their own ecosystems. And according to the survey presented by Lex, actually a large majority of Polish professionals, Polish lawyers, already use such tools, or at least publicly available general purpose LLMs, large language models, regularly, with over 70% using generative AI at least once a week, according to this survey. So this reality creates a real and growing imbalance. Lawyers can now build complex, well-supported arguments at great speed, while courts lack comparable tools. And this is not merely an efficiency concern, yes, because it also raises direct questions about equality of arms and the court's ability to maintain its epistemic authority when confronted with AI-assisted submissions that it cannot efficiently enough verify. Another area that requires at least mentioning is what I call the gray zone. And perhaps this is the most uncomfortable observation in the entire paper concerning the actual use. The unknown but likely non-negligible extent to which individual judges already use general purpose AI tools such as ChatGPT, Claude, Gemini, Copilot, Perplexity, to name but few, in their daily judicial work without any disclosure to the parties or to the court administration. The institutional cause is clear. The government has failed to adopt the necessary legal framework or to execute a coherent strategy for AI deployment in the courts in a timely manner. As a result, this vacuum is being filled by individual judges acting on their own judgment, simply driven in no small part by the very real pressure of excessive caseloads on their dockets. And the risks connected with this situation are, of course, substantial. First, hallucinated legal reasoning may be inadvertently incorporated into judgments and remain undetected. Secondly, and more fundamentally, where AI influences a judgment without disclosure, the parties have no opportunity whatsoever to know about or challenge that influence. The duty of disclosure implied by the equality of arms principle and the transparency requirements is therefore structurally violated. The third problem is also refers to data protection concerns, because uploading case file materials to consumer AI platforms obviously raises serious GDPR questions if such events occur. What makes the situation particularly acute is an informal don't ask, don't tell dynamic. Very few judges actually publicly admit using AI in their judicial work. No one is formally asking, no one is formally prohibiting it. So the constitutional framework in reality operates in a normative shadow. The last element of the current state of affairs before I go to the conclusions is what I call the out-of-court frontier, the place where AI is already operational in Poland. Of course, this is the domain where AI-assisted adjudication becomes reality at a very fast pace. The most concrete example is the project developed by Use AI for Ultima Ratio, the Court of Arbitration at the Association of Public Notaries. The system assists arbitrators with comparative analysis of cases and awards, and also with drafting the grounds for arbitral decisions. And in general speaking, arbitration for sure provides a more permissive constitutional environment, precisely because it's grounded in party consent, where parties accept AI-supported decision-making and judicial review remains available. The constitutional objections that I described earlier, they are substantially reduced. This for sure makes arbitration a fertile testing ground and also a very good comparative model, which is worth observing and to some degree also taking some observations for the practice of the judiciary. Conclusions. Taking a step back, and the picture that emerges is the following. Justice system is at the crossroads. It moves with belated but gathering pace towards AI integration, yet doing so without an adequate normative and institutional architecture in Poland. The constitutional and procedural constraints that I have described, they actually do not preclude this development. They actually precondition it. But the conditions are currently not being met, not because the technology is unavailable, but because the legislative and institutional framework that would make its deployment useful, sound, and constitutionally legitimate has not yet been built. Additionally, to ensure that any meaningful deployment of AI in civil proceedings remains constitutionally compliant, the existing statutory framework governing the relationship between the Polish Ministry of Justice and the judiciary requires systemic overhaul. The current model, which grants the executive numerous instruments of influence over courts and judges, often only nominally framed or disguised as administrative oversight, should be restructured so as to genuinely reflect and safeguard judicial independence in line with the standards and best practices observed in stable democracies committed to the rule of law. Last sentence is that until these critical changes happen, the risk of ad hoc, fragmented, or even tilted, unsupervised, and constitutionally dubious AI deployment will remain the defining feature of AI use in the Polish civil justice system, including the civil litigation. Thank you very much for your attention. It was a big pleasure.
I also thank you, Professor Olaś. It was an excellent presentation. It's a matter of also a matter of culture and generation. Young people and young generation are more willing and can accept and adopt all this new culture, because it's not only a legal problem, it's a social problem. It's not a problem, it's a different social situation. And it does have to do, as you also already mentioned, with the principles of constitutional principles. And these constitutional principles belong to the heart, to the core of European civilization. So it's a major problem to safeguard this constitutional principle, because in the end we are going to ask the question, what did we gain and what did we lose in the end by accepting or by rejecting artificial intelligence? Thank you very much. Thank you very much. It was a very, very good presentation. And now I give the floor to Dr. Eugenia Ferentinou, a tutor in the Open University of Cyprus, and one, with your permission, of the most promising young proceduralists in Greece. Eugenia, the floor is yours.
Thank you very much, Professor Makridou. Good afternoon, dear colleagues. I would like to warmly thank you for attending today's conference, and mostly I would like to express my gratitude to our hosts, Professor Makridou and Professor Diamantopoulos, for their kind invitation and for welcoming us to this dialogue. 1 second to start sharing my presentation. All right. So, we are here to discuss a topic that is placed at the very frontier of modern jurisprudence, the integration of artificial intelligence within civil litigation. But first of all, some historical data. The origins of artificial intelligence can be traced back to British mathematician Alan Turing's groundbreaking essay titled Computing Machinery and Intelligence, published in 1950. There, he first questioned whether machines could replicate human behavior by introducing a so-called imitation game. However, the formal foundation of this scientific discipline occurred a few years later, with the 1955 Dartmouth proposal. Authored by 4 American researchers, this proposal is widely acknowledged as the true origin of this field, as it officially coined the term artificial intelligence and established its fundamental guiding principles. Following these early milestones, the field's progression throughout the 20th century was highly volatile, characterized by cycles of high expectations, followed by significant periods of disappointment and stagnation, known as AI winters. It wasn't until the late 20th century that significant growth in computing power and rapid algorithmic innovation sparked the massive resurgence we see today. Today, in the third decade of the 21st century, as we all know, AI is no longer a theoretical imitation game. It is progressing at an exponential rate, fundamentally transforming numerous sectors, for example, from healthcare to public administration. However, when we attempt to integrate artificial intelligence into the legal sector, we encounter unique and profound complexities. Legal science relies intrinsically on nature-human language, which is here infused with normative elements, societal values, and principles that demand careful teleological interpretation. Processing this nuanced legal language, whether found in statutes, judicial decisions, or scholarly writings, poses a significant challenge to any algorithmic system. Therefore, the central inquiry of our topic today is how we can navigate the intricate dichotomy between technological efficiency and the imperative conservation of fundamental fair trial rights. To fully grasp these complexities, our initial step must be to establish what exactly we mean when we speak of artificial intelligence. Currently, the most prominent and technology-neutral definition is provided by the OECD and the European Union's Artificial Intelligence Regulation, so-called AI Act. They define an AI system as a machine-based system that operates with varying levels of autonomy and infers from the input it receives how to generate outputs, such as predictions, recommendations, or decisions that influence real or virtual environments. So, recognizing the profound power of these outputs, how does the European Union attempt to regulate such a disruptive force within the halls of justice? The European AI Act introduces a tiered system based on the principle of proportionality, and it explicitly classifies AI systems used by or on behalf of judicial authorities as high risk. This includes any AI designed to research facts, interpret legal provisions, or apply the law to individual cases. This strict classification reflects the reality that these technologies hold the power to significantly influence democratic values, the rule of law, and procedural fundamental rights, particularly the right to an effective remedy and a fair trial. Therefore, the EU framework insists that the use of AI tools can support the decision-making power of judges, but it must never replace it. The final decision-making must always remain a human-driven activity. Consequently, high-risk legal AI systems must adhere to mandatory requirements, including fundamental rights impact assessment, the use of high-quality training data to prevent discrimination, and most importantly, robust human oversight. It is worth noting, however, that AI systems designed solely for routine administrative or preparatory tasks, such as formatting text or anonymizing documents, are exempted from the high-risk category, as they do not materially affect the outcome of legal decisions. While the European framework provides the overarching principles, it is crucial to examine how these are applied nationally as well. So, turning to the national level, in Greece, we encounter a proactive regulatory environment. In more detail, the legal framework for artificial intelligence in Greece is primarily defined by Law 4961 of 2022, which establishes the foundation for safe and transparent AI utilization while complementing existing regulations like the GDPR. Under Article 4 of this law, public sector entities can only use AI for decision-making if it is expressly provided for in specific legislation that includes appropriate safeguards. Before any AI system is even deployed, Article 5 mandates a comprehensive algorithmic impact assessment. This assessment scrutinizes the system's intended purpose, the data it processes, and the potential risks it presents to human rights, with particular attention to vulnerable groups. Transparency is another cornerstone of the Greek approach. Article 6 imposes strict transparency obligations, requiring entities to publicly share technical parameters and ensure that citizens affected by an AI-assisted decision can clearly comprehend the logic behind it. Furthermore, to combat the black box problem, which we will discuss shortly, the law mandates that contractors developing AI for the public sector must deliver systems that can be thoroughly examined by its official users. So, the state must be able to study how the system operates and understand the exact parameters used for decision-making. Lastly, I would like to emphasize a key aspect of the Greek law. Article 7, paragraph 3 of Law 4961 of 2022 requires that any public contract for designing or developing AI systems must ensure compliance with legal standards at every stage. This means protecting human dignity, privacy, non-discrimination, gender equality, freedom of expression, accessibility, workers' rights, and the principles of good administration. By embedding these requirements in the procurement process, the Greek legal framework aims to connect technical compliance with ethical and legal values. However, beyond legislation, Greece has already moved into practical implementation. Since May 2023, the Court of First Instance of Athens has successfully utilized natural language processing, NLP, to automatically identify lawyers' names and registration numbers embedded within court decisions, automating tens of thousands of document retrieval requests. Additionally, pilot programs are currently using advanced AI models like Roberta to anonymize court decisions. These systems carefully mask sensitive citizens' data while intentionally keeping the name of judges and lawyers public. Looking ahead, there are ambitious plans to introduce document summarization using large language models and to deploy digital assistants like the chatbot Protath.ai to guide citizens through legal procedures. These proactive developments within the Greek legal framework highlight that the transformation of our civil justice system is actively underway. However, as we examine the practical implementation of these tools, it is essential to distinguish between basic digitalization, such as the transition to electronic case files and online hearings, and the actual deployment of artificial intelligence, which leverages machine learning and to autonomously interpret and evaluate complex legal data. This brings us to our next critical question. How are these AI technologies actually being utilized in civil courtrooms worldwide today? To systematically understand the current landscape, we can categorize these applications into a three-tier classification, a taxonomy proposed by German scholar Michalis. This three-part scale is structured based on two key factors: the technological complexity of the applications and the depth of their intervention into the core judicial process. The first tier involves AI acting purely as an organizational tool. Here, AI streamlines administrative workflows to increase efficiency. For instance, in Germany, systems like Codify categorize extensive case files to distinguish disputed from undisputed facts. This level also includes crucial AI systems used for the anonymization of judicial decisions before their publication, though these still mandate strict human oversight to comply with data protection frameworks like the GDPR. Nevertheless, we must be cautious, as even administrative AI is not without risks. Automated case distribution systems have sparked serious legal controversy regarding the right to an independent tribunal. For example, the SLPS system implemented in Poland has already prompted a pending preliminary ruling request to the Court of Justice of the European Union. By the way, roughly just a month ago, on 19th of March, Advocate General of the European Court, Spielmann, delivered his opinion on the SLPS case. His main point is that the arbitrary withdrawal of cases from a judge without clear objective criteria and reasoned justification violates the guarantees of judicial independence and the requirement of a tribunal established by law, regardless of whether the judge consented to the withdrawal. However, he clarifies that the subsequent use of fully automated, without human intervention, random case allocation system is permissible under EU law, provided that the system is accompanied by safeguards to prevent any arbitrary use or any undue interference. Finally, he concludes that effective judicial protection does not require member states to grant individual judges a specific personal right to appeal case allocations decisions, as long as the lawfulness of those allocations can be effectively challenged and reviewed during the actual legal dispute at the initiative of the litigants or by the court's own motion. So, returning to the three-tier categorization of AI applications within civil courts, we move to the second tier, where we find AI operating as a decision-making supporting tool. This involves more complex applications that actively assist judges. Here, AI radically aids legal research by using advanced semantic status and precedents rather than just matching basic keywords. It is also employed to efficiently summarize extensive legal texts and actively assist in drafting legal documents, which significantly reduces the judicial workload in mass proceedings. Additionally, artificial intelligence is rapidly changing how evidence and discovery work is taken in today's legal system. AI tools now help lawyers and judges analyze evidence, assess witness credibility using voice and facial cues, and efficiently handle large volume of information. These technologies can also calculate damages and verify digital evidence with blockchain. In common law countries, predictive coding, also called technology-assisted review, makes it faster to find important electronic documents, though there are still ongoing debates about how training data is selected. Yet, this tier is fraught with critical risks, most notably the phenomenon of AI hallucinations. That is to say, large language models can entirely fabricate judicial opinions or factual details out of thin air, making independent human review not just recommended, but absolutely essential. Overall, at this stage, AI delivers efficiency, but critical questions around fairness and transparency remain. This brings us to the third and undoubtedly most controversial tier, the automation of judicial decision-making. This tier involves delegating substantive decision-making power to algorithms. Let me be clear. Under current European legal frameworks, entrusting binding judicial decisions exclusively to AI is strictly impermissible. EU law and constitutional principles dictate that the judicial authority is vested exclusively in human judges, as algorithms fundamentally lack personal independence, accountability, and the semantic comprehension needed to evaluate a legal argument. Overall, to allow an algorithm to issue a fully automated judgment would violate human dignity, treating citizens as mere data points rather than human beings. So, although fully automated judicial rulings are strictly prohibited in key court proceedings, semi-automated decision-making is becoming increasingly common on the edges of civil justice. For example, the American Arbitration Association now uses an AI-powered arbitrator that provides recommendations with human oversight. Online platforms like Canada's Civil Resolution Tribunal and the UK's Smart Settle One employ algorithms to resolve low-value and debt claims. Australian family law tools forecast asset division after divorce, though they still face challenges around overall fairness and lack of human empathy. Estonia has introduced algorithm-driven payment orders with similar reforms considered in Germany as well. China's smart courts go further, deploying AI avatars to assist judges, automate draft judgment, and use big data and blockchain to streamline enforcement. These global innovations highlight how AI may support, but not replace, human judgment in civil justice. In light of the above advancement, the integration of AI into substantive judicial processes brings us to the core dilemma of our time. How do we balance technological efficiency with the imperative preservation of fair trial guarantees, a right inextricably enshrined in Article 6 of the European Convention of Human Rights? The reality is that the deployment of advanced AI poses formidable, multi-layered risks to the right to a fair trial, a cornerstone of democratic legal systems. To process the true impact of this technology, we must unpack three deeply interconnected parameters. To be more concise, the first major threat concerns the indispensable right to a reasoned judgment, a fundamental pillar ensuring that a tribunal has substantively examined a case. A judge must provide clear reasoning so as citizens know they have been genuinely heard. However, modern AI, especially machine learning and deep neural networks, still operates as an opaque black box, meaning its internal mechanisms remain unintelligible. So, if a judge bases even a section of the decision on such an opaque system, his or her capacity to provide a complete and logically sound justification for the outcome of the court ruling is severely restricted, directly conflicting with the obligation to provide a reasoned judgment under Article 6, Paragraph 1 of the ECHR. Furthermore, this lack of transparency conflicts with Article 22 of the GDPR, which grants individuals the right to contest automated decisions. This means that without meaningful insight into the AI's logic, this right is rendered rather hollow. Furthermore, AI operates fundamentally at a syntactic level. It identifies statistical correlations between words, but completely lacks the semantic capability to comprehend legal contexts, societal values, or normative principles. Consequently, AI might generate a superficial reasoning, a mere veneer of legality that lacks true causal and normative substance. But if the underlying logic is concealed, the losing party's right to appeal is eviscerated, as they cannot ascertain whether they lost due to a factual error, a misinterpretation of the law, or a hidden flaw in the algorithmic code. Crucially, the opacity of the black box does not only obscure the reasoning of the machine, but also it sets a dangerous psychological trap for the human judge interacting with it. And this leads us directly to our second threat, the compromise of judicial impartiality. That is to say, while AI could theoretically serve as a debiasing tool, its practical implementation introduces a severe psychological risk known as automation bias. This is the human tendency to place excessive and critical trust in automated recommendation, viewing machines as inherently objective. Driven by heavy workloads, human judges may transition from critical evaluators to passive approvers of algorithmic conclusions. This is deeply dangerous because even an AI system is trained on biased data, it will inevitably reproduce and amplify those biases. However, the impact of this technology does not stop at the judge's bench. The combination of inaccessible algorithms and biased judicial outcomes directly spills over into the dynamics between the litigants themselves, leading us to our third and final threat, the disruption of adversarial proceedings and the principle of equality of arms. More precisely, the black box architecture directly undermines the adversarial process. If the logic underlying an AI-generated conclusion is inaccessible, the affected party is stripped of the right to meaningfully cross-examine it or expose its methodological flaws. At the same time, we may witness the emergence of a stark digital divide. On the one hand, well-resourced corporate entities and large law firms possess the financial capital to deploy cutting-edge technology, AI legal tools, granting them a strategic advantage. On the other hand, smaller firms and private individuals lack access to these expensive tools and the technological proficiency to challenge them. This creates a severe resource asymmetry, structurally disadvantaging less resourced litigants and challenging the equality of arms in the courtroom. In conclusion, artificial intelligence has an undeniable technological potential to transform the administration of civil justice. However, its application currently is and should remain limited to peripheral and ancillary functions. The core judicial activity, which is the teleological interpretation of the law and the nuanced application of the facts to legal rules, cannot be sufficiently met by mere logical calculation or statistical correlations. It requires human empathy, ethical reasoning, as well as personal independence and accountability. Overall, ensuring fair trial rights means that the integration of artificial intelligence must be careful, transparent, and proportionate, so that AI remains strictly an auxiliary tool. Ultimately, we must remember that justice is a fundamentally human endeavor, and the right to have our cases heard and adjudicated by a human authority is a right we must vigorously protect. Thank you very much for your time and attention.
Thank you very much, Dr. Ferentinou. We have the opportunity to attend a very interesting presentation. There are a lot of threats, as you mentioned many times in your presentation. At the moment, the opinion of the European Court of Justice is a relief, but nobody knows for how long. Okay, thank you very much. And I give the floor now to my colleague, Professor Georgios Diamantopoulos, who is going to chair the next session.
Thank you very much, Professor Makridou. It's my pleasure to welcome you all to the last part of today's online conference, in which we will examine issues related to e-auction. Our next speaker, Professor Kinga Flaga-Gieruszyńska, will now introduce us on the topic of e-auction under Polish law. Without further delay, I invite her to share her insights with us.
Do you see everything?
Yes, everything is perfect. Thanks.
Thank you very much. And the first of all, thank you very much for invitation. It's the great honor and pleasure for me to be with you. And today I would like to present the topic of electronic auctions under Polish law in enforcement proceedings. So an electronic auction is a relatively new solution because in the case of movable properties, the 2017, and in the real properties, the 2021. And this solution constitutes an alternative to the traditional public auction conducted by the court bailiff. And it was introduced primarily to the modernize enforcement proceedings and adapt them to the realities of the digital environment. And one of the main reasons for its introduction was the need to increase the accessibility of auctions. In the traditional model, a participant had to be physically present at the specific place and time, whereas in the case of an electronic auction, participation is possible via ICT system. Another important objective was to increase the competitiveness of the sale. A greater number of participants means a higher chance of achieving a higher price, which benefits both the creditor and the debtor. The introduction of electronic auctions was also intended to streamline and accelerate enforcement proceedings, as well as to increase the transparency of entire process, because this solution also reduces the risk of collusion between bidders aimed at the purchasing assets at artificially low price. And at the outset, it's important to clarify what may constitute the subject of an electronic auction under Polish law. The first of all, they includes movable property, which is the primary category to which this form of sale applies. Importantly, an electronic auction may concern not only entire items, but also two fractional shares in movable property, which is particularly relevant in the cases of co-ownership. Moreover, the scope is broader and also includes claims on over property rights. This means that the subject of an electronic auction may consist not only of tangible assets but also of intangible rights that have economic value. In such cases, the legislator provides that the provisions governing enforcement against movable property shall apply, including the rules on the sale by electronic auction. And the next subject of an electronic auction may also include real property. As the rule, the sale of real property by way of electronic auction covers the same rights as those they may be sold in the traditional auction. This includes not only ownership, but also perpetual usufruct, fractional share in real property, and cooperative ownership right to a residential unit. At this point, it's worth briefly explaining two of these concepts, as they are quite specific to Polish legal system. The first, perpetual usufruct, is a specific property right under which a natural or legal person may use land owned by the state treasury or a local government unit for a long period. Typically, it's 99 years, in some cases between 40 and 99 years. And the cooperative ownership right to the residential unit is a limited property right that entitles the holder to use a dwelling which formally remains the property of a housing cooperative. This right is transferable, inheritable, and may be encumbered with a mortgage. However, since July 2007, housing cooperatives have no longer been allowed to establish new rights of this kind, but it's for now very popular kind of possession of apartments, so it's an important part of electronic auctions. And moving on, it is worth taking a closer look at the status of sale by electronic auction in the relation to movable property. As a rule, the sale of seized movable property in this form does not constitute a separate procedure. It is based on the provisions governing traditional public auction, which still play a fundamental role. This means that certain elements are in principle derived from already existing solutions. At the same time, the legislator has introduced specific provisions concerning electronic auctions which adapt this model to the digital environment. This is the part I will focus on. So we are dealing with a hybrid model. On the one hand, based on the traditional structure of the public auction, and on the other hand, adapted to operate within the ICT system. Electronic auction is an alternative to traditional public auction. It does not replace it entirely, but operates alongside it as one of the possible forms of sale. Its introduction is therefore intended to increase the effectiveness of enforcement by creating an additional, more accessible mechanism of sale, which increases the chances of finding a purchaser and obtaining a higher price. And the similar approach applies to real property, although in this case the regulation is more complex and more formalized. As a rule, the sale of real property by electronic auction is based on the provisions governing the traditional sale of real property. This means that, as in the case of movable property, the electronic auction does not create a completely new legal structure, but rather builds on the existing model, which has been adapted to operate in a digital environment. In the case of real property, the role of the court is significantly greater. It is the court, not the court bailiff, that decides on the award and the transfer of ownership, reflecting the higher value and legal importance of real property. Certain exceptions to the traditional rules have also been introduced. For example, the provisions concerning the recording of the course of the auction by means of image or sound recording devices do not apply. This is because the entire procedure takes place within the ICT system, which itself ensures the recording and transparency of the process. In practice, this results in a hybrid model too, like in the movable property, one that is rooted in the traditional rules governing enforcement against the real property, but at the same time adapted to the digital environment. And moving to the initiation of the sale by electronic auction in relation to movable property, the key role is played by the creditor's application. As a rule, it's upon the creditor's application, the court bailiff conducts the sale by the electronic auction. It is important to note that such an application may only be filled after the seizure of the movable property has been effected. In practice, it is quite common for a given item of movable property to be seized in order to satisfy claims of several creditors. So in such a situation, it is sufficient for just one of the creditors to request a sale by way of electronic auction for it to be carried out. As regards the timing, the application should be filled before the auction date is set, or together with an application for setting the date of the second auction. And it also worth paying attention to the practical consequences of filling an application for sale by way of the electronic auction. Where such an application is filled, the court bailiff, as a rule, removes custody of the seized movable property from the debtor and entrusts it to another person. This purpose of this measure is to protect the property from damage or removal. However, there are certain exceptions. Custody may remain with debtor if the debtor provides a guarantee of proper custody, or where the custody has already been established, or where the property has been placed in the court deposit or entrusted to an appropriate institution for safekeeping. For example, some property with artistic value. Another important aspect is the timing of the auction. Where custody has been removed from the debtor, the electronic auction may not commence earlier than 2 weeks from the date of removal of custody. Is the guarantee the good proceedings. And when we have the real property, it is important to note a key difference in the initiation of sale by way of an electronic auction, because the sale of real property is in this form is conducted ex officio, meaning that it does not require any application or request from the creditor or debtor. This means that the initiative does not lie with the parties, but with the court bailiff, who applies this form of sale in the order to broaden the pool of potential purchasers, or to reduce the risk of collusion between bidders aimed at acquiring attractive property at the lower price. Where the enforcement concerns several real properties or several parts of a single real property, the court bailiff is required to notify the debtor of the planned sale. Moreover, the debtor has the right to indicate the order in which the individual real properties or their parts are to be auctioned. This is important right, as it may affect the scope and outcome of the enforcement proceeding. It is possible that the sale, for example, the first property, will be sufficient to satisfy the creditors and making the further auctions unnecessary. This solution is intended to maintain a balance between the interests of the creditor and the protection of the debtor by allowing the debtor a certain degree of influence over the course of the enforcement proceedings. And the key element of the electronic auction of movable property is, of course, the ICT system through which the entire procedure is conducted. And the sale, this kind of property in this form, is carried out entirely within this system, which supports the whole process. The operator of this system is the National Council of Court Bailiffs, which is responsible for its functioning. Access to participation in the auction itself is restricted. Only the court bailiff and registered users may take part. A user is understood as a natural person who holds an account in the ICT system. But the notice of sale is published on the website of the National Council of Court Bailiffs and may be accessed without authentication. As regards timing, the notice should be published at least 1 week before the auction. In the case of perishable goods or livestock, this period is shorter and amounts to at least 3 days. This solution therefore combines two elements. On the one hand, restricted access to participation in the auction, which ensures secure identification of bidders. On the other hand, the broad accessibility of information about the sale, which enhances transparency and increases interest among potential purchasers. Similar solutions also apply to real property with regards to the use of the same ICT system. In this case as well, the sale by the electronic auction is conducted entirely via IC system operated by the National Council of Court Bailiffs, and participation in the system is conditional upon the creation of the individual account in the system, which, similarly to the case of movable property, allows for proper identification of participant and ensures the security of the entire procedure. In the case of real property, there is also an important difference compared to the traditional model with regard to the publication of the notice of sale. The notice is published on the website of National Council of the Court Bailiffs at least 2 weeks before the auction date. In practice, this result is a clear simplification and centralization of the system of informing about auctions, which enhances transparency and improves the accessibility for potential purchasers. And another important element of this procedure is the notice of electronic auction in relation to movable property. In this notice. This notice contains the basic information about the subject of the sale and the conditions of the auction. In particular, it specifies the appraised value, the starting price, as well as the place and time at which the movable property may be inspected. In addition, it includes the photographs of the items offered by sale for the sale and information on the commencement and closing of the electronic auction. The notice also contains an important clause concerning the third-party rights. According to this clause, such rights do not, as a rule, constitute an obstacle to conducting the auction or making the award, unless the person concerned proves before the auction begins that they have brought an action for release of this property from enforcement and have obtained a ruling staying the enforcement. Of course, the notice also contains a number of additional details which are not discussed here. I put this information in my report. Finally, it should be noted that the notice is removed from the website after the auction has closed, which brings the informational stage of the proceedings to the end. This solution is intended primarily to minimize the processing of the debtor's personal data. And as regards the real property, as regards real property, the notice of electronic auction is more detailed and contains a broader range of information. First of all, the court bailiff specifies the real property to be sold, including its location, economic purpose, and the details of the land and mortgage register or the collection of documents. The notice also includes information that the auction is conducted by the electronic system, as well as the exact time of its commencement and closing. As in the case of movable property, it indicates the obligation to pay a deposit and its amount, as well as the time during which the real property may be inspected by potential purchasers. An important element is also the indication of the appraised value and the starting price. The notice further also contains a clause concerning the third-party rights, which analysis I will omit during this presentation. And important aspect is that in the case of real property, the notice of electronic auction is accompanied by additional documents and information. In particular, together with the notice, the court bailiff makes available the report on the description and valuation of the real property with detailed information on the condition of this property and its value. Similarly to the movable property, the notice in this situation is also removed from the website after the auction has closed. Another important element of the procedure is the payment of deposit in the case of electronic auction of movable property. As a rule, the deposit must be paid into the bank account of the court bailiff no later than 2 working days before the auction begins. The relevant date is the date on which the court bailiff's account is credited. Before participating in the auction, the bidder must also provide certain data in the ICT system. This includes, among other things, the information on marital status and, if the bidder is married, whether the property is to be acquired as part of joint property or separate property in marriage. In addition, the bidder must indicate whether they are acting in their own name or as a representative of another person. In the latter case, this must be notified in advance, no later than 5 days before the auction date. If there are deficiencies in the data or the deposit has not been paid, the court bailiff may request the bidder to remedy these deficiencies and under the pain of exclusion from participation in the auction. Whether the bidder acts on behalf of another person, it is also necessary to submit an electronic copy of the agency of representative within the prescribed time limit. It's the court bailiff decides on admission to the auction, confirming the payment of the deposit and the provision of the required data by formally admitting the bidder to participate. In the event of refusal, the information is also communicated via the ICT system. As the regards real property, the rules concerning the payment of deposit are largely similar. In this case as well, the deposit amounts to 1/10 of the appraised value of the real property. As with the movable property, it must be paid into the bank account of the court bailiff no later than 2 business days before the commencement of the auction. As before, together with the payment of deposit, the bidder is required to provide in the ICT system the data necessary for issuing the decision on the award. The bidder must also indicate whether they are acting in their own name or as a representative of another person, and provide, it's very important, any additional data required under specific provisions. These provisions may, for example, relate to restrictions on the sale of real property for non-European Union foreigners. And the further elaborating on the formal preparation of an electronic auction, in the case of real property, it is important to note the additional formal obligations imposed on the bidder. In there are deficiencies in the data or documents, the court bailiff requests the bidder via the ICT system to remedy them. This request is mandatory and is made under pain of exclusion from participation in the auction. This applies in particular where participation in the auction requires authorization by the public authority or proof of authority to act on the behalf of another person. In such cases, the bidder must submit electronic copies of the relevant documents. The time limit for the submission is generally 3 days, but in any event no later than the day preceding the auction. Once all acquired information has been provided and the payment of the deposit has been confirmed, the court bailiff admits the bidder to participate in the auction. If these conditions are not met, the bidder is not admitted to the auction and the refusal is communicated via the ICT system. This solution is intended to ensure that only entities meeting all formal requirements participate in the auction, thereby enhancing the security and reliability of the transaction. And turning now to the conduct of electronic auction in relation to movable property, it is important to highlight several key organizational rules. The first of all, the time of commencement and closing of the auction is specified in advance in the notice of auction. This means that participants know exactly when they may submit bids and when the auction will end. At the same time, the court bailiff sets the auction in such a way that both it its commencement and closing fall between 9 a.m. and 2 p.m. On business days. This time frame is intended to ensure that the auction takes place during the operating hours of civil courts, which in Poland do not have strictly fixed office hours. The duration of the auction is, as a rule, 7 days. In certain cases, for example, where the property is perishable or where its storage generates excessive cost, this period may be shortened. However, it may not be shorter than 2 days. An important mechanism is the so-called automatic extension of the auction. If a bid is submitted within the last 5 minutes before the scheduled closing time, the closing time is extended by the further 5 minutes. If additional bids are submitted during this extended period, the auction continues to be extended each time by another 5 minutes until no further bids are submitted. This solution is designed to ensure competition between bidders and to prevent situation in which a bid is submitted at the last moment, leaving no time for others to respond. As regards the conduct of the electronic auction in relation to real property, many solutions are similar to those applicable to movable property. As before, the time of commencement and closing of the auction is specified in the notice of auction, and the court bailiff sets them so that they fall between 9 a.m. and 2 p.m. on business days, and the duration of the auction is, as a rule, 7 days. And of course, it's the same rule that during the auction, bidders submit bids via ICT system, and the auction is won by the bidder who has offered the highest price at the time of closing. And we have, as with the movable property, the same mechanism of automatic extension of the auction. After the auction has closed, the court bailiff informs the participants via ICT system which bidder offered the highest price. An important element is also the possibility of cancelling the auction. If the enforcement proceedings are discontinued, for example, due to satisfaction of the creditor's claim together with enforcement costs, the court bailiff immediately cancels the auction. These solutions are extended to ensure flexibility of the proceedings and to adapt them to situations where the objective of enforcement is achieved before all planned auctions have been completed. And after the closing of electronic auction in relation to the movable property, the next step is the award. As a rule, the court bailiff immediately after the closing of auction awards into the person who offered the highest price at the moment. The information about the award is then immediately announced in the ICT system, while the data of the purchaser are not disclosed, which serves to protect their privacy. The notice of the award is also served on the purchaser via the ICT system. Participants in the auction may lodge a complaint regarding the conduct of auction. The time limit for doing so is 3 days from the date of closing of the auction, and the complaint must be submitted via ICT system. If the complaint is not upheld, the court bailiff promptly forwards it to the court together with the documentation necessary for its examination. This mechanism ensures control over the proper conduct of the auction. In the case the real property, the proceedings relating to the award differs somewhat from the applicable to movable property, as a greater role is played by court. Bidders and persons who were not admitted to the auction may lodge complaints exclusively via ICT system. Other persons may also submit complaints in this manner, provided that they hold an account in the system. After the auction has closed, the role of the court bailiff in this situation, the real property, is primarily to transmit the case to the court. The court bailiff prepares and forwards the record of the conduct of the auction, all unresolved complaints, and the documents necessary for the award. This should be done without delay and no later than within 1 week from the closing of the auction. Decision on the award is then made by the court or court referendary in closed session within 1 week from the receipt of the relevant documents. Where necessary, the court may hear the bidder who offered the highest price as well as other participants in the proceedings. It is therefore clear that in the case of real property, the procedure is more formalized and judicial control plays greater role, reflecting the higher value and legal importance of such assets. And it is also worth discussing the issue related to acquisition of movable property after the closing of electronic auction. If a complaint is lodged by persons who were not admitted to the auction or by the creditor or the debtor against the award, the purchaser obtains specific right to renounce the acquisition of the movable property. The time limit for this is 1 month from the date of the closing of the auction. Importantly, this renunciation may be made via ICT system, which reflects the general principle of conducting this procedure in a digital form. If the purchaser does not exercise this right, they are obliged to pay the purchase price within a very short time frame. As a rule, the payment should be made on 1 day following the service of the notice of the award, either during the office hours of the court bailiff's office or by transfer to the bank account of the court bailiff no later than 6 p.m. on the day. If that day falls on a Sunday or a public holiday or on Sunday, the payment may be made on the next business day. As before, the date of payment is deemed to be the date on which the bank account of the court bailiff is credited. The final stage of enforcement against the real property is also acquisition. And the concluding stage of this procedure is the transfer of ownership, which takes place after the decision on the award becomes final. At this stage, the court bailiff requests the purchaser to pay the purchase price. As a rule, this must be done within 2 weeks from the service of the request by making a payment to the deposit account of the Ministry of Finance, with the deposit already paid being deducted. Upon the purchaser application, the court may set a longer time limit for the payment, but it may not exceed 1 month. If the purchaser fails to pay the price within the prescribed time limit, the deposit is forfeited and the effects of the award lapse, meaning that the sale of real property does not take place. If, however, the purchaser pays the price correctly and on the time, the court issues a decision on the transfer of ownership. And the conclusions, the first of all, the electronic auctions constitute a modern complement to traditional forms of sale rather than a complete replacement. They operate as an alternative solution that increases the flexibility of enforcement proceedings, but now we see that for Polish legislator this form of sale is priority. Secondly, there is a clear trend towards digitalization. The ICT system plays a central role at every stage of the procedure, from the submission of the application through the conduct of the auction to its completion. Another important conclusion is the increased accessibility and competitiveness of the sale. Thanks to the possibility of participating online, the number of potential purchasers is higher, which contributes to achieving a higher price and better satisfaction of creditors, but also debtors. At the same time, the legislator seeks to maintain balance between efficiency and the protection of participants. This is reflected, for example, in the availability of complaint mechanism and in the significant role of the court in the case of real property. It also should be emphasized that although the regulations concerning both kinds of properties are based on similar principles, in the case of real property, the procedure is subject to stronger judicial control. In summary, electronic auctions enhance the efficiency, transparency, and accessibility of enforcement while forming part of the broader process of digitalization of justice system. Thank you very much for attention.
We cordially thanks Professor Kinga Flaga-Gieruszyńska for her elaborative analysis. Please join me in welcoming Professor Dimitris Michiotis, who will be presenting his insights on e-auction under Greek law. Please, Professor Michiotis, go ahead.
Thank you very much, Professor Diamantopoulos. First of all, I would like to express my sincere thanks to Professors Makridou and Diamantopoulos for the honor of including me among the speakers of this international conference. The present report examines the principal procedural issues arising from the conduct of electronic auctions under Greek law, focusing exclusively on compulsory auctions as a means of realizing seized, movable, and immovable assets within enforcement proceedings. The aim is not to provide an exhaustive presentation of the relevant procedural provisions, but rather to identify those issues of broader interpretative and comparative importance which reveal the institutional logic of the electronic auction and its place within the system of compulsory enforcement. As a methodological starting point, the analysis proceeds from the teleology of the institution. Two parameters are decisive on this respect. First, the steadily increasing digitalization of law in general and of enforcement proceedings in particular, a development observable across European legal orders. Second, the public character of compulsory enforcement itself. These two parameters do not always operate harmoniously. At times, they complement one another, while at others they stand in tension. The electronic auction can be properly understood only if it is approached not as a mere technical innovation, but as an institution embedded in the public law structure of compulsory enforcement. A first issue concerns the legal nature of the compulsory auction. Greek law distinguishes between compulsory auctions, which follow the compulsory seizure of movable or immovable property, and voluntary auctions conducted either by agreement of the parties or pursuant to a judicial decision. Both are now conducted exclusively by electronic means, yet the present report is concerned only with the compulsory auction. The question of the legal nature of the compulsory auction is of particular importance because it determines the interpretative framework within which the relevant procedural rules must be understood. Older Greek legal scholarship, especially during the late 19th and early 20th centuries, adopted the view that the compulsory auction was a private law sale contract. According to that position, the successful bidder was the purchaser, while disagreement existed as to the seller. Some identified the debtor against whom enforcement is directed, since he remains owner of the seized asset until completion of the action, while others regarded the enforcing creditor as the seller, since he is one effectively exercising the debtor's rights. This view still survives to a considerable extent in Greek case law. Contemporary Greek legal scholarship, however, supports the opposite position, namely that the compulsory auction is of a public law nature. Influenced by German doctrine, it is regarded as a public law contractual relationship of a sale-like character in which the contract parties are the successful bidder and the state. The notary, acting as auction officer, functions as a state organ rather than as a private intermediary. The practical importance of this issue is considerable. It affects the applicability of the civil code rules on sale, the possibility of challenging the auction because of defects of will, the operation of the prohibition of abusive exercise of rights, and the consequences of legal defects affecting the auctioned asset. It is especially significant because under Greek law, adjudication through auction constitutes a derivative, not an original mode of acquisition of ownership. The preferable view is that the public character of the compulsory auction does not derive merely from the classification as an institution of procedural law, but from its functional role with the system of compulsory enforcement. The creditor does not address the debtor, but the state invoking a public law claim to enforcement. The competent organs, the bailiff and the notary, exercise public authority and do not act on the basis of private mandate. This has important consequences. The rules of enforcement are not designed only for the benefit of creditors, but also for the protection of the debtor. Since enforcement is carried out by state organs, it must ensure both the highest possible auction proceeds and the prevention of disproportionate liquidation of debtors' property. This is the true teleology of the compulsory auction, whether in its traditional or electronic form. The institution serves not only the satisfaction of creditors, but the balanced protection of all parties involved. This is further confirmed by the fact that under Greek law, the proceeds of the auction are distributed according to the principle of proportional distribution among creditors, subject only to statutory priorities. The status of seizing creditors does not confer subsisting priority. The electronic auction was introduced in Greece in response to significant practical difficulties observed in traditional auctions. Auctions conducted with the physical presence of participants were frequently obstructed by fraudulent practices, particularly the deliberate exclusion of prospective bidders by debtors or competitive bidders, often resulting in unsuccessful auction proceedings. The phenomenon intensified during the financial crisis, when organized political interventions often prevented auctions from taking place at all. The electronic auction was introduced into Greek enforcement law in 2017 as an optional mechanism. The enforcing creditor would choose whether the auction would be conducted in the traditional manner or by electronic means. 1 year later, the mandatory use of electronic auctions was established for both movable and immovable property. There is no longer any possibility of choice. All compulsory and voluntary auctions are conducted electronically. This reform was justified on grounds of legislative policy. Traditional auctions based on a single sale bid often resulted in property changing hands at values significantly below its real worth. Electronic auctions were considered capable of maximizing economic benefit while minimizing personal and procedural costs. More importantly, they eliminate the social tensions and practical obstacles associated with physical auctions. From a comparative perspective, Greece belongs to the limited number of European legal orders that have made electronic auctions the exclusive means of realization for both movable and immovable assets. Many legal systems remain more hesitant, particularly regarding immovable property. German law offers an important example. For movables, the bailiff may choose between a physical auction and an online auction, Internet Versteigerung, with the latter now constituting the rule. Auctions are conducted through official platforms in order to preserve their public character and avoid recourse to commercial auction platforms such as eBay. However, German law does not provide for electronic auction of immovable property. This is justified by the judicial control exercised in immovable auctions, which are governed not by the CPO, but by special law and characterized by strict formal guarantees. Spain, by contrast, has introduced mandatory electronic auctions for both movables and immovables. France limits live electronic auctions to movables, while English law permits online auctions of seized goods without providing a centralized official platform. The comparative overview confirms an important point. Electronic auctions are not simply private commercial auctions transferred into the field of enforcement. Their public character remains decisive. This leads to the policy-oriented conclusions of the report. First, the electronic auction should be welcomed because it significantly expands the circle of prospective bidders. Since physical presence is unnecessary, participation becomes easier and broader, increasing the likelihood of higher bids and therefore better satisfaction both for creditors and for debtors. Second, no objection can be raised on the basis of the principle of publicity. Publicity should not be understood as requiring physical presence at the place of the auction, but rather as ensuring effective public access to the process and the possibility of monitoring its development. Third, electronic auctions reduce procedural tensions. Fraudulent exclusion of bidders and similar pathologies of traditional auctions disappear almost entirely. Fourth, disadvantages inherent in the electronic form are difficult to identify. The inability of bidders to inspect the auctioned asset is often mentioned, but this problem exists equally in traditional auctions. According to Greek law, the electronic auction is conducted through a dedicated online auction platform managed by the local notarial associations. 4 categories of users participate in the system: visitor, auction officers, bidders, and debtor observers. Prospective bidders must first be registered and certified in the electronic system, and at least 2 working days before the auction must deposit a guarantee equal to 30% of the first bid price. The auction is then conducted online through the submission of successive bids, and the property is adjudicated to the highest bidder who acquires the status of successful bidder and is obliged to pay the auction price. If the electronic auction cannot be conducted or is interrupted due to technical failure of the electronic systems, the procedure is considered to remain pending rather than cancelled. It is then continued upon the enforcing creditor's instruction after a new electronic announcement by the auction officer, while any bids already submitted before the interruption remain valid. Greek courts have repeatedly faced cases in which a bidder, either because of unfamiliarity with the electronic platform or because of haste, enters a bid manifestly higher than intended, for example, by accidentally adding an extra zero. The immovable property is adjudicated to him at that price, and the mistake is obvious from the sequence of prior bids. The legal problem is whether such a manifest error invalidates the auction, and if so, by what procedural mechanism the invalidity may be invoked. Greek procedural law makes the issue particularly difficult. Bids are irrevocable and cannot be conditional. The notary has no authority to correct the bidder errors, even manifest ones. The objection against enforcement is the exclusive remedy for challenging the validity of the auction, but statutory standing to bring it belongs only to the debtor and the creditors, not to the successful bidder. Three views have been advanced. The first denies any protection to the successful bidder and concludes the legislative intervention is required. The second accepts that the bidder cannot challenge the auction immediately, but may later defend himself if enforcement is brought against him or if a re-auction following the default of the successful bidder is conducted because he refused to pay the auction price. The third view, which appears to be the correct one, accepts that the successful bidder may exceptionally bring the objection against enforcement. In such a case, a strict grammatical interpretation standing rules is insufficient. The successful bidder is neither debtor nor creditor, but his position is clearly deserving of protection. Requiring him to wait for a subsequent re-auction would not only lead to the definite forfeiture of his guarantee, but would also undermine confidence in the institution of electronic auctions itself. The proper solution is therefore to recognize, by way of exceptional and teleological justified interpretation, the successful bidders standing to bring the objection against enforcement. The ground of that objection should be the violation of the constitutional principle of proportionality and the principle of good faith conduct of enforcement proceedings. The error concerns the fairness of the auction procedure itself. The electronic auction, therefore, illustrates a broader truth. Digitalization does not abolish the classical principle of enforcement law. It merely requires their reinterpretation under new technical conditions. The public character of compulsory enforcement remains the decisive interpretative criterion, and every procedural solution must be tested against that foundation. Thank you very much for your attention.
We kindly thank Professor Michiotis for his very interesting contribution. Since we have already completed the full cycle of presentations, I invite Mrs. Ioanna Mamali, Judge of the Piraeus Court of Appeal, to sum up the concluding remarks from the topics covered by our esteemed contributors. Hence, after thanking all of you sincerely for your time so far, I give the floor to Ioanna Mamali.
Hello, everyone. Last but not least, I hope, allow me at the beginning to express my gratitude for the privilege of taking part in this conference and for the opportunity to address such a distinguished academic audience. The subject under discussion, namely the digital transformation of civil proceedings and the incorporation of artificial intelligence, has already evolved beyond a merely topical issue into a central field of reflection concerning the future functioning of the justice system. Having regard to the conclusions presented throughout the conference, it is apparent that modern civil procedure is subject to a profound and multi-layered process of transformation. This evolution is not confined to the technological field alone, but extends to the institutional and normative dimensions of procedural law, insofar as it aims to reconcile the preservation of established procedural guarantees with the increasing demands for efficiency, speed, and technological innovation. Regarding the first thematic section, the civil trial, it is apparent that the process of digitalization does not proceed in a uniform or linear manner. Both the Polish and the Greek legal systems exhibit an evolutionary development characterized by gradual and at times fragmented incorporation of technological tools. Starting with the Polish civil proceedings, the digitalization has evolved from fragmented, insular solutions to a more comprehensive transformation, particularly accelerated by the COVID-19 pandemic. Initially, the Code of Civil Procedure introduced provisions for electronic communication as early as the year 2000, but these remained largely ineffective until the implementation of the electronic writ of payment procedure in 2010. This development demonstrated the practical potential of technology in alleviating judicial workload, yet it also revealed structural limitations, particularly the phenomenon of what has been described as insular digitalization, whereby technological tools remain limited to specific procedural stages without forming a coherent digital ecosystem. The pandemic served as a catalyst, transforming temporary emergency measures into permanent components of the civil justice framework. The evolution from optional fragmented solutions to mandatory systematic implementation demonstrates the judiciary's adaptation to contemporary technological demands while maintaining procedural safeguards and access to justice principles. For the Greek legal system, the law provides comprehensive regulations for electronic procedures such as electronic filing, digital service of documents, teleconferencing and hearings, while maintaining optional rather than mandatory implementation. Technical systems are well developed with appropriate security measures and data protection. Some interpretive issues remain regarding deadlines and procedural requirements. The legislator has prioritized solutions that preserve access to justice for those without technological capabilities. However, the lack of official statistics makes it difficult to assess the practical success of digitalization efforts. Although Greek civil procedure law has successfully integrated modern technology across all procedural stages, further legislative clarification is needed in certain areas, and better data collection is essential to evaluate the effectiveness of these digital transformation efforts. A common characteristic in both legal systems, Polish and Greek, is that digitalization, notwithstanding its potential to improve efficiency and access to justice, does not per se guarantee procedural effectiveness. Its success depends on consistent and coherent implementation, the availability of adequate technical infrastructure, and the capacity of institutions to adapt accordingly. In this sense, digitalization ought to be conceived not as a simple technological upgrade, but as a fundamental restructuring of the procedural framework. Regarding the second thematic section, AI and civil proceedings, both analyses adopt a critical approach to AI in civil justice, emphasizing that efficiency gains cannot justify compromises to procedural fairness, transparency, and democratic legitimacy. The integration of AI into civil adjudication must be gradual, carefully regulated and consistently subordinate to human judicial authority. The judicial function cannot be reduced to a purely automated process. It involves evaluative judgment, contextual understanding, and the exercise of discretion, elements that are closely linked to the human dimension of adjudication. AI integration in Polish civil proceedings is both constitutionally possible and practically necessary, but only within carefully defined limits and under appropriate institutional safeguards. The constitutional framework establishes a clear threshold. AI may assist, support, but it may not administer justice in the constitutional sense. This boundary between administration of justice and legal protection constitutes the operational criterion for assessing any specific AI deployment. The opportunity for beneficial AI integration is real, but it requires political will to accompany technological ambition with institutional reforms that can make such integration constitutionally legitimate. And concerning the Greek civil proceedings, the analysis addresses the implication of AI for fair trial rights in civil litigation. The black box problem is identified as a central threat, particularly in relation to the right to a reasoned judgment. Opaque AI systems, especially those based on complex machine learning models, often lack explainability, making it difficult or impossible to trace how legal rules and factual inputs are translated into outcomes. This opacity undermines the obligation of courts to provide clear and intelligible reasoning, which is essential for effective appellate review and legal certainty. Transparency is presented as a precondition for the effective exercise of procedural rights, particularly the right to contest decision and evidence. Further analysis is devoted to judicial impartiality, algorithmic discrimination, and automation bias. While AI is sometimes portrayed as a neutral tool, AI systems may replicate or amplify existing biases embedded in training data or design choices. Moreover, automation bias may lead judges to over-rely on algorithmic outputs, thereby shifting decision-making authority away from human adjudicators and threatening judicial independence. The principle of equality of arms is also examined critically. The analysis notes that the emergence of a digital divide in civil litigation, whereby well-resourced litigants can deploy advanced AI tools for predictive analytics, document review, and strategic planning, while less resourced parties lack access to comparable technologies. This asymmetry risks structural inequality within adversarial proceedings and challenges the fairness of the process. Regarding the third thematic section, electronic auction, the Polish law provides for an electronic auction system for the sale of movable property in judicial enforcement proceedings. The electronic auction constitutes an alternative to the traditional public auction and has been introduced to enhance the efficiency, transparency, and accessibility of enforcement sales, allowing an unlimited number of interested bidders to participate remotely without physical presence. Overall, the electronic auction system in Poland represents a significant step toward the digitalization of enforcement proceedings, aiming to balance procedural safeguards with efficiency, legal certainty, and broader public participation. Coming to Greece, the Greek legal system, there are many legislative reforms which transform the electronic auction from an optional tool into a mandatory procedure for both movable and immovable property. This shift in legislation was motivated by policy concerns, including the elimination of distortions observed in physical auctions, the expansion of bidder participation, enhanced transparency, and the achievement of higher auction prices. As a result, compulsory auctions under Greek law are now conducted exclusively through electronic means. Electronic auctions represent a significant modernization of Greek enforcement law. Their interpretation, however, must remain echoed in the public law character of enforcement proceedings, constitutional safeguards, and the underlying purpose of achieving fair, transparent, and proportionate satisfaction of monetary claims. Both the Polish and the Greek experiences demonstrate that the success of electronic auctions depends on maintaining a delicate balance between efficiency and the protection of procedural guarantees. Enforcement proceedings, despite their functional orientation toward creditor satisfaction, remain governed by principle of public law, which require the safeguarding of the rights of all parties involved. Now coming to the final conclusions, first of all, we must say that digitalization operates at multiple levels within the system of civil justice, each level producing distinct legal and institutional implications. At the level of electronic civil trial, digitalization primarily serves to enhance procedural efficiency without affecting the essential adjudicatory function of the judge. At the level of artificial intelligence, however, it gives rise to fundamental constitutional considerations concerning the nature, the scope, and permissible limits of adjudication. At the level of enforcement proceedings, digitalization restructures procedural mechanisms while preserving their inherent public law character. Secondly, technology does not replace the administration of justice. Rather, it redefines the framework within which justice is delivered. Consequently, the integration of digital tools must be guided not solely by consideration of efficiency, but also by the overriding obligation to safeguard fundamental procedural guarantees. Thirdly, the effective integration of digitalization cannot be achieved through legislative intervention alone. It presupposes proper implementation, institutional coherence, technological reliability, and continuous assessment of its practical effects on the justice system. The prevailing conclusion is that the future of civil justice does not lie in the uncritical adoption of technological solutions, but their careful, principled, and measured integration within the framework of the rule of law. Under the current European legal framework, artificial intelligence must remain an auxiliary tool subject to strict human oversight and transparency requirements in order to remain compatible with fundamental fair trial guarantees. Artificial intelligence and digital technologies may substantially enhance the administration of justice, provided that they remain subject to meaningful human control, transparency, and accountability. Only under these conditions can digitalization fulfill its promise, not as a substitute for justice, but as a means for strengthening its effectiveness, accessibility, and legitimacy. Thank you very much for your attention.
We cordially thank Ioanna Mamali, of course our professors, the audience, and the Sakulas Publications. We are kindly waiting for your final papers till the end of May, so as our book will be published till the end of June. Thank you very much again. Have a nice summer, of course.
Thank you very much.
Thank you very much.
It
was a great pleasure.
Thank you very much.
For us too.
Thank you very
Thank you for being with us today.
Thank you.
Bye-bye.
And hopefully till the next meeting.
Yes, we strongly hope it.
Definitely. Maybe we could see each other in person.
Let's hope that.
Yes.
I agree with you, Anna. Let's meet each other in person, normally.
Yeah.
See you.
Bye-bye.
See you, bye.